listening to the totality of your interview 4 days after, that you never tell the ranger that you saw anybody that was dressed in black with long hair and a fire and a gun?
Correct.
You agree that you never told him that you saw dirt flying up on the playground? That was, to you, I guess, putting two and two together, you felt like you were being shot at, which was your opinion.
Correct.
You never told the ranger any of those things?
I'm listening to that now.
Right. And that was 4 days after it happened.
Correct.
And you would agree he gave you every opportunity to say everything that you remembered about what happened.
Yes.
And seeing the shooter and seeing somebody with a gun on your school would have been something that you would have told him at the time.
I would think so, yes.
In the dirt and you connecting that to their bullets being fired in your direction.
Yes.
Okay. So the question I have is, when you talked to the prosecutor on those incidents, did you tell them those details about seeing the person in black and with long black hair or with long hair and a firearm? And did you tell them about seeing dirt being kicked up at the playground?
I believe so, yes.
All right, Your Honor. And so based on that, we have never gotten any notice from the prosecution, and that is clearly an inconsistent statement with the statement that she gave. The prosecution has never provided us. This is clear under Brady. It's clear under Michael Morton that if this is the first time that I'm hearing of this in a trial of this magnitude is when she testified on the stand about it. And so if she did report these things to the prosecution, we were entitled to that to prepare for this. And this is a trial by ambush.
Okay. Response?
We're checking to see if it is indeed part of the grand jury testimony that was turned over to them.
Okay.
Would definitely be a clear violation.
Let's wait a sec.
Yes. It's provided in the transcript that we provided to them on, what's 134. Here's the part which talks about the extension cord.
I agree that she said that before. I do not see in the I do see in the grand jury transcript there was talk about dirt flying up around the kids. I do not see where she described seeing a shooter, seeing a person with a gun matching the description of the shooter. And apparently she told the prosecution that before trial. I mean, Judge, that's an incredibly important detail that I'm finding out about now in front of the jury.
And how's that Brady or exculpatory, Your Honor?
Well, it's like insanely different. What I want to say is it is 180 degrees different than her prior testimony to the grand jury and her prior statement to the ranger, and it is of a matter of such importance because it has placed the gunman on the south side at the same place where my client was, where he responded to and where he went to, and so if this witness has told, and I understand witnesses testify, they remember things differently, but when the prosecution hears something that the witnesses remember differently than anything that we have, it's their obligation to provide that to us, because that would be what could be used for impeachment.
But we provided with the grand jury testimony that had about the dirt, whether or not it was a man in black, they've already stipulated that there's a man in black that was there.
I agree, but not at that location at that time. And this is a man dressed all in black, not just all in black, with long hair and a firearm and a gun.
like there was more than one man in black in the gun
But
at the south end of Robb Elementary?
the prosecution, I'm sure, is not trying to intentionally miss the point, which I'm sure that the court understands my point, which is it's not about who did the shooting. Of course, we all agree with that, but at what time, when and where and how, and what teachers had identified a shooter or had seen a shooter on campus?
Well, the location is pretty important, Mr. Turner. Do we have anything that you show in your notes? You turn that over to them?
About the man in black? No, Your Honor, I don't.
Specifically the location at that particular time?
Well, I guess the idea is the witness has testified that she told the state. Does the state acknowledge to the court that they were told that?
I said, I believe so, sorry.
What?
Yeah. I mean, you know, the thing about it is that this woman was initially interviewed, you know, in a very traumatic event. So there's going to be things that she remembers, you know, for as time goes on. But I agree with Mr. Turner, that's not exculpatory. You know, we all knew there, I mean, when saying to them, hey, there's a shooter, all black with a long rifle, is not information that they didn't already have throughout this case.
In opening statement, they said that Melody Flores said the man that was in all black, but she got the gun wrong. So this is
I
not
think
like
his
new
complaint
information.
is more to the location of the man in black in relationship to where his client was.
I don't think she said anything about where his client was, first of all.
She put him at-
Second of all, I think the testimony will be that Melody Flores saw him in the same spot that this woman has said it was. There's no new testimony there. There's no new evidence. There's nothing different than what they already know.
She never told us the specific location that she saw him, about that south end of the door. She never told us that.
Okay. So what are you asking for?
Well, can I have a moment?
Pretty quick, yeah.
Yeah, just need a little bit to talk to them.
Yeah. Finish the record, so go ahead. Before they ask for their remedy, we'll go ahead and ask your question.
As far as the conversation you had with the prosecutors and the man in black, did you discuss, or do you have a firm memory that you discussed where he was, or did you simply discuss him and you saw the man in black?
I don't remember. Are you talking like during the grand jury? During the grand jury, or when?
No, when you talked to the prosecutors in preparation for trial.
Oh, I don't remember now.
You don't remember?
If I discussed a location, no.
And I'd also like to ask Miss Mitchell, do you have any notes that we're discussing where?
I guess if we're going to take testimony, I'll tell you what, ma'am, let's do this. I don't want you going back up to the fourth floor. Could you go with one of our bailiffs and just step out in the hall momentarily, and we'll bring you right back in? Don't talk to anybody about the case if you do me that favor. All right, Ms. Mitchell, you'd raise your right hand. You solemnly swear the evidence in the testimony given the cause will be the true self you got?
Yes.
Mr. Turner, we can just do it from council table if nobody objects. Go ahead.
Thank you. Were you there and conducted an interview with Stephanie Hare?
Yes, for trial preparation.
And did you take notes as a part of that?
Yes.
Do you have any notes as to Ms. Hale telling the prosecution where the man in black was?
No, she told us there was a man in black. She looked, she saw a man in black with a long rifle. But she didn't tell us that he was specifically at that location at the south end on the sidewalk. She did say.
Thank you. And I'd also call Mr. Garza, Your Honor. Oh, I'm sorry, pass the witness.
Yeah, but clarify for me, what was in the grand jury testimony that you did disclose?
That there was dirt flying up.
Okay, all right.
Yeah.
Question?
Ms. Mitchell, the notes that you're referring to, on what date was that interview done?
I have to go back to my calendar. It was sometime in mid-December. It was right before Christmas.
Of 2025?
Yes.
Were you the only prosecutor present at that interview?
No, it was me, Mr. Garza, and Mr. Turner.
All right. And you were conducting the interview?
No, Mr. Turner was.
And in that interview, the witness that we're referring to told you she saw a man dressed in black with long hair and a long rifle.
Right.
All right. And you noted that she had never said that before at the time that she said that.
I didn't note that.
Well,
We're prepping her, so I can't say that I specifically noted that.
but I mean, you in just the preparation, you would have noted that a fact like that an additional person seeing the shooter at the time before the shooter entered the building outside, you would have noted that as a significant fact. You would agree with that?
I would say that he was seen by several people, so one other witness saying they saw him, such as Ms. Flores, or, was part of that.
All right, but I guess what I'm saying is that whether or not he was seen, you understand and know that not only is location important, but time is important. Where the shooter is at a certain time, you note that that is an important detail.
That is an important detail, but I wouldn't say that I was, at the time, had dissected the time frame with her to the point that it was so significant that it stood out to me.
Well, and I guess that you'd also understand that different witnesses at different points in time, viewing a shooter in different locations, all of those things are important details as to know not just where the person was, but when in time the person was. And different witnesses will provide different times, right?
Right.
You understand that as a concept.
Right, I understand that.
And I'm not talking down to you, I'm just trying to make sure that, I know you understand it. I just want to make sure that it's clear on the record. And so, because this focus on whether or not she talked about the location, if that's the first time that she ever said location, and it just happened to be the location in trial that is where our client was, and now she's put the shooter on the south side of the building, on the sidewalk, looking like he's going into the building on the south side in trial today. Are you saying she never said that to you before? In your notes?
Okay, were you asking me two different questions, like seeing him there versus seeing him specifically on the sidewalk. The term "the sidewalk" today caught me off guard, because I had never heard that before.
Had you ever heard her say that she had seen him either going into the south side of the building or approaching the south door?
No,
Did she ever tell you that he was on the south side of the building?
no,
So nothing in your notes. Now,
no. 'Cause like I
okay,
said,
so here's my question. At a time when you're talking to a witness and for the first time they're telling you that they saw the shooter, neither prosecutor or anyone in the room thought to ask her, where did you see the shooter? That wasn't a question that came up in anybody's mind, to ask her where the shooter was?
You know, you're getting very nitpicky. Let me tell you something. When we were prepping these witnesses, I was running a law office, and so I was in and out of interviews. So I can't say that she said that and I, like, oh my God. You know, it wasn't that type of reaction for me, so that's the best I can say.
I guess, I know, but as a person present in the interview, I mean, this is who
What I
Mr.
can say
Turner
is
called.
today, when she said that he was on the south end, I was surprised. That's what I can say.
And we were too, or that she saw him at all. But you were not surprised, though, when she testified that she had seen him.
No, because she said that she had seen him. She said that during trial prep.
And so-
What she had seen is a guy with long hair with a gun.
And so you understand, with all the information that you provided us, and that your office provided us in discovery, you understand how we would be surprised that she testified that she saw him.
No, because I would assume that y'all knew that, given everything, given all the information that's been provided to y'all, that y'all would know that he's, the testimony, the evidence is that he's on that south end of that building shooting into room 102, right? And so if he's at 102, that's the farthest room on that end, on that south end, then somebody's gonna see him, because there's casings from that room.
But somebody is going to see him versus a person in a particular place at a particular time saw him has a lot of it's a whole different thing. And you would agree with that? That's why I was asking that question. Place and time are both important considerations when we're talking about Adrian Gonzales' conduct. What he saw, what he could see, what he could know, what others knew. Those are all important considerations.
But we already have other witnesses that say that he was, that the shooter was seen at the south end of the building.
Right, and
We
you would...
have other witnesses.
Okay, and so...
So I didn't think that that would be a surprise to y'all.
Well, let me ask you this. So you say you have other witnesses that will say that. And now you have provided, you would agree, you have provided a witness that will corroborate those other witnesses, right? And make those other witnesses seem more credible instead of their testimony standing alone. Right?
Right.
Okay. And so that would be an important thing for us to know before we started this trial. And to know when you knew it. You would agree with him.
I would agree that that was already known, that was out there.
Well,
That's
I'm
why
not
I don't understand why it's a surprise to you.
Because you didn't report it when she told you that. That's why. Because you didn't turn it over when she told you that, and it was something she had never said before. And I think you will agree with me that has not been turned over by your office in any shape or form before.
Well, I would agree with you that I so asked you to come to my office and review our file. That was on the record. I said, I want y'all to come and look through our complete file to make sure that you have everything. And that was agreed to, but then I was never contacted. So I did make our file available on the record before trial.
And you understand the prosecutor's obligation is not on the defense. The prosecutor's obligation
No, I
belongs solely to
understand
the
that, but I wanted to
prosecution.
make sure that this is tons of evidence. I want to make sure y'all had everything, you know, made our discovery portal available, we gave y'all a server. I wanted to make sure y'all had everything. So I did make that available.
I'll pass the witness.
I had a few follow-up questions on timing, if I may. Ms. Mitchell, to start with, there are casings not only in front of 102, but also south of that. Is that correct?
Yes.
And those casings are not attributable to anybody other than the shooter. Is that correct?
That's right.
And both pictures and statements have been given as to that. Is
Yes.
that correct? And as far as timing, The only timing this witness has said is when she heard firecrackers, she headed to her building and saw the defendant. I mean, the gun, is that correct?
Right.
Did she say anything about Adrian Gonzales being there or not being there?
No.
Did she testify to anything about Adrian Gonzales being there or not
No.
being there? So the timing is simply that as she hears what she believes to be firecrackers and where there are casings, she sees the man in black. Is that correct?
Right.
And so how does that timing in any way impact Adrian Gonzales?
I mean, it's speculation in that sense, because she can't know our defensive strategy or what we're doing. But it's pretty clear, Judge, it's pretty clear that we have these things down to the second. Prosecution presented the things in a big blurb. We have it to the second, and the second matters, and every second matters. And so timing is important to the defense strategy. I'll just represent to the court. I don't need Ms. Mitchell to testify about how important it is to my
We have the
strategy.
timing of when every shot was fired, including the shots at the south end, Your Honor.
Okay.
We do have exact.
Well, let's finish up the evidence that you want to. Did you have any other questions of Ms. Mitchell? Any other questions?
No, Your Honor.
Okay, did you have any other follow-up cross of Ms. Mitchell on?
I'd ask you to examine her records in camera, or her notes in camera, to find out if that's the
Did you
case.
want to call Garza or not?
Yes.
Okay, let's finish the evidence. All right. You solemnly swear the evidence in the testimony given the cause to be the truth, so help you God.
I did.
Judge,
Go ahead.
could you come up here? Come up here.
Yeah, let's do it for the witness stand. You're a little far away. Okay, thank you, sir. Go ahead.
Thank you.
Tell us who you are
My name is Ricardo Garza Jr.
and what do you do for a living.
I'm an investigator for the DA's office in Uvalde County.
Were you present when Stephanie Hale was interviewed?
Yes.
And do you recall her saying anything about where the shooter was?
No.
Do you recall her saying that the shooter was in black?
Yes.
And did she say anything about the white car or Adrian Gonzales during that period of time?
No.
Did she ever give any testimony about seeing Adrian Gonzales or where he was in proximity to the shooter?
No.
And did she give any indication of timing?
No.
Was she looking at a phone, a cell phone, as to timing,
No.
whether in minutes or seconds?
No.
So she could give us no clue as to what time she saw the person in black.
Correct.
As the witness.
Investigator, so I guess first and foremost, you would be willing to get on the stand and testify that the witness, and she testified, had never said before that this person was on the south side.
I don't recall her saying that.
Well, that's different than what you testified to, which is that she did not.
Well, she did not.
Okay. So as far as the person, that her telling you, you've looked through this file, I'm sure.
Yes.
Yes. And you know that it's significant when people were able to see the shooter from the time that he went in the culvert to the funeral home to walking down to the shots he was firing and who could see him and what was going on at the time. You know those are significant facts.
Correct.
Okay. And the shooter was apparently, I guess in this December 2025 interview that you were present for, a question was asked, or Ms. Hale told you guys in that room that for the first time that anybody knows that she saw the shooter with a black shirt, wearing black, long black hair, and a and a long gun or a rifle. Yeah.
She said that.
Right. And you recognize that to be the first time that she has ever said that to anybody.
I don't know if that was the first time she said to anybody.
Well, I guess to anybody in your investigation that would come over in discovery to us.
Correct.
You knew that was the first time she'd ever said it.
Correct.
And nobody in that room thought to say, where did you see him?
That was not asked.
Okay, so as an investigator, as prosecutors, You have a significant fact that's come out, and you're saying there was no follow-up questions to her saying that she saw a man dressed in black with a rifle and long hair. Nobody followed up. Nobody said where. Where were you and where was he when you saw him?
That was not asked.
As an investigator, do you understand that that follow-up question would be a common question that any investigator or prosecutor that you know of would ask? If somebody has come up and said a material fact like that. Where were you and where was he when you saw him?
Correct.
And nobody in that room asked.
Correct.
I'll pass the witness.
No further questions.
Okay, you step down, have a seat back at a council table.
May I address the court on one issue, Your Honor? Yes, sir. I'd just like to point out that the indictment says and accuses Adrian Gonzales of the time that occurred after Melody Flores informed him where the shooter was. That's the time that is relevant and material to this case. Where the shooter was at any time before that has no bearing on Adrian Gonzales or his conduct in this case.
Well, we can't delve into their trial strategy, but I'm gleaning that there is some issue in that regard for the trial strategy. So, any other evidence on the matter?
Not from the defense, Your Honor.
Okay. Arguments?
I guess, well, the only thing that I would like to ask, because we started to speak to my client and then they put on more evidence, so I had to come sit over here. I'd just like a brief moment to talk to him. I mean, it's his case, it's his part of. I want to know how he feels about, because there's certain remedies that are severe.
Well, there's several remedies, Heath, et cetera, that we can talk about, but yeah, talk to him.
Thank you, Judge.
So this is pretty significant, right?
This could be huge. We don't know yet what the judge is going to do. We don't even know. So the last thing that defense is saying, they're hinting at, there are some really big remedies, and I'm going to talk about what those are in a second. But we need to talk to our client to see if he wants us to make that argument. And so what those remedies could be are the defense asking for a mistrial. Judge, because we argue that the state has violated the law, under the U.S. Constitution, they've referenced Brady versus Maryland as a U.S. Supreme Court case that says the prosecution must turn over all exculpatory evidence. And then they've referenced the Michael Morton Act, which is Texas law, that basically says the same thing, what the state has to turn over when. And so if the judge finds that they did violate that by not turning over this information, then that could render the trial, basically unfair, and therefore grant a mistrial, and that would end this trial, and would start over from scratch. So this is a huge moment. It's really big, and
Is this sloppy on the prosecution's part?
Yes, but.
Okay.
Typical lawyer answer. This is not uncommon. So I deal with a lot of different DA's offices from, I'm focused here in Dallas, so all over the kind of the Dallas North Texas Metroplex area, and all of those different DA's offices have varying different degrees of how open their file policy is. The safest thing to do, in my opinion, for the prosecution is also what the defense wants, which is a complete open file policy. Meaning, not only do we get all the evidence, all the police reports and the original witness statements and all that, but if you meet with a witness, if you call a witness, if you interview a witness, if you prepare one of your witnesses for trial, we want notes on what was said. And the reason for that is, if they've been saying the light was green, the light was green, and then they tell you the light was red, that's a change. And that change may be important. And if that change is very important to the case, then it could be so important that you want to turn it over. I say it's the safest thing to do to have a completely open file policy because right now the prosecution is forced on their back foot to say, what do we remember her telling us?
Right. This is not a good look. You don't
Yeah.
really, the prosecution doesn't want to be on the stand, and they don't want their investigators on the stand like this. This is not.
No lawyer wants to be put under oath and testify in their own trial. It's not a good look. I guarantee the judge is not happy right now with them because this is in putting the entire trial in jeopardy, which is frankly a waste of the taxpayers' money and everything else.
Well, let's stop for a second because one of our commenters is saying, hey, that they were stepped away for a little bit and they want to make sure.
Yeah.
So
let's reset.
In case you stepped away for a little bit, we had a teacher from the school was on the stand, and she was testifying about what she saw and heard that day, and she described that she had saw dust kicked up, and she described seeing a man in black with a rifle
With long
walking
hair.
on the south side.
Yep.
Well, unfortunately, that testimony, that description, she did not give that description to the ranger originally when she spoke to the law enforcement 4 days afterward. She met with the investigators, she met with the prosecutor's office back in December, and they re-interviewed her, which is not unusual because they'll prepare a witness for trial. And in that interview, she described having this man, seeing this man in black, but they're saying she never mentioned he was on the south side.
That's right.
And they're saying, well, we opened our files to you and you didn't come over and get it. Essentially, I mean, I've summed that up pretty well.
Yeah. And earlier we talked about when the state was making when the defense was grilling into this poor teacher. We said, oh boy, this is risky. She's been very, very likable, very compelling testimony. You don't want to be seen as beating up on her. And I said, it better be a big issue. Well, this is why. Because we don't have access to every piece of evidence the way they do. They knew their case backwards and forwards, and they knew that's not what she said. Not only is that not what she said, but it's really different. Why is it different? Well, because the south side is the side that Gonzales is on. And they're
saying he doesn't have line of sight.
He never had a line of sight. And they said that in their opening statement. From a defense lawyer standpoint, you say, look, I would never have made that argument in front of a jury had I had any evidence from the state, which they're required to give me, that gave me any indication that that may not be true. Now the state has basically laid a trap for me that I stepped into, and I look disingenuous in front of the jury when the reality is I was arguing based on the evidence they gave me. So they whether they meant to or not, they set a trap, and now my client's not going to get a fair trial.
Do you think they intended to set a trap? It doesn't feel like it.
No,
It feels
I
like
don't think
it's
so.
just the prosecutor, and I don't know her name. Maybe the folks out in the comments have caught her name. But the female prosecutor said, "Well, I opened my file, and you said you can come on over." What do you say to that?
That is not the way the law works. So the prosecution has the affirmative duty to tender to the defense any exculpatory evidence. It's not come over and view it when you want.
They have the duty.
They have the duty, especially if I can view your file, how can I view your memory of what that witness said in a prep session? That's not in your file. That's not a witness statement. This is why really good prosecutors I've worked with, I had a case in Denton where I was shocked. It was the first time I'd ever had a prosecutor who literally every prep session he did, he turned over his written notes of literally handwritten of while he's talking to the witness. And, there's no argument that he gave me everything. And that's why when I said, the safest thing to do is just turn over your file, the prosecution should take notes and they should turn over those notes. And, oftentimes I think prosecutors say, well, it's work product, this is our inner strategy. The reality is, unless it really is notes on your strategy, they should probably be turning it over, not just for fairness to the defense, but to protect themselves, because ultimately it's better for them, it's better for the system, it's better for a fair trial.
I know one thing, the judge does not look happy.
He does not look happy
That
because
is-
he knows.
If you'll approach the bench real quick, I'm going to do
Okay, they just killed the mics again in the courtroom.
Which is not surprising because they're having an off-the-record conversation. So, you know, it's not surprising. It's, you know, the jury doesn't get to hear this. We don't get to hear this. It's going to be interesting because the defense has just had a conversation with their client to say, do you want us to argue, do you want us to argue
Do you want to call for a
mistrial?
mistrial?
Right. Because, look, it is probably a long shot. I don't think it's a Hail Mary. I really don't. I think there's a real chance the judge grants this because it is a big violation if he thinks it is a violation. But, from a defense strategy standpoint, the jury hasn't got to see any of this. So all the jury would get to see is they get brought back in. This defense stands up and says, we move for a mistrial. If the judge denies it, it almost appears like the defense is
beating up on the
straws,
teacher, right.
beating up on the teacher, making ridiculous arguments.
And they're not lawyers, so they don't understand.
They don't know.
I think for folks out here, let's talk a little bit about the genesis. We've talked about Michael Morton. We've talked about Brady. Why does Michael Morton exist? This is a really important law. How did this come into existence?
Yeah, I mean, the way to start with that is who is Michael Morton? Well, he was a wrongfully convicted and eventually exonerated person in Texas. And the genesis of that was that if you turn over all the evidence, we don't get wrongful convictions. And so in the old days, we very frequently would have trial by ambush where the state would turn over almost no information. My very first murder case that I ever handled was in like 2006 or 7-ish, and murder case, and I was given about 20 pages, and that was it. So that's the way things were back then. It very, very much was trial by ambush. Almost no information was given, and thank God the Texas legislature decided that was unfair, both to defendants, but also just to the concept of justice. And so now that's Brady, that's Michael Morton, is you have to turn over everything.
Right, it's a whole different world.
The jury. Yeah, please.
All rise for the jury.
Come on up, ma'am, and have a seat. Witness stand. Okay, please be seated in the courtroom. Ladies and gentlemen, we had to take up a matter required by law outside your presence. As I've told you before, please don't hold it against either side. We need to, because of issues that arose during that hearing, we were already going to have to quit tomorrow for the medical appointment at noon or 1 o'clock, so we were not going to be here in the afternoon. To further deal with this issue, I'm going to continue this matter till Thursday morning at 9 o'clock for the jury. We will be here tomorrow dealing with a matter outside your presence, but I'm continuing the jury until 9 a.m. Thursday morning, and hopefully all the other issues can get resolved during that period. So thank all of you for your consideration and your patience. It's very, 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 very important with this day delay that you remember my instructions and do not read anything, watch anything, or listen to anything that may be in the media about the case. Don't make any personal investigations. Don't talk to anybody about the case, and don't let anybody talk to you. We will start on time, 9 a.m. Thursday, with this witness back on the stand. So have a good day off. I hope everything works out otherwise, and we'll see you at 9 a.m. on Thursday. Would everyone rise for the jury? You're excused for the evening. Thank you all very much. Okay, you can be seated in the courtroom. Ma'am, we're doing that continuance because of some issues that arose. And what I'd like for you to do is be back on Thursday morning at 9. But this is very important. The rule has been invoked. And it is a specific rule concerning witnesses. And it means you cannot talk to anyone about the case, about your testimony you gave in here today, or anything about the case to anyone other than the lawyers. That means family members, spouses, anybody, until you're told the case is over with and you're released from the rule. All right? We'll see you back here 9 o'clock Thursday. We'll see you all 1:30 tomorrow.
Wow.
Wow.
That
Yeah.
That is-
I was just saying in the comments to some of the folks on YouTube that I think this is, look, we don't know what the judge is going to do. Both sides are going to go brief this issue. They're all going to find case law. They're going to come back and they're going to argue. But, so we don't know what the judge is ultimately going to do yet. But it's very clear to me that the judge is taking this very seriously. And there is a very real chance that he could grant a defense motion for a mistrial. Otherwise, if he was thinking, you're grasping at straws, this is ridiculous,
We just move on.
He would just rule, say, overruled, make your motion, move for mistrial, overruled, let's go. So the fact that he hasn't done that, I think, says a lot.
This was kind of an unexpected curveball.
Curveball of curveballs, yeah.
Because I'm trying to remember a time, and I'm sure I have seen a time when a prosecutor's been put under oath. I think it has happened, but not something like this.
Yeah, you usually see a DA investigator put on much more often because, there's a reason you put the DA investigator on, because they're not one of the lawyers in the case, and they can say, I was in the room, this is what I heard, blah, blah, blah. But in this case, and I think that goes to show how seriously the prosecution's taking this, because they didn't start with the DA investigator. They said, uh-oh, this is real. Let's call the prosecutor. Let's also call the DA investigator. That way we have two people, not just one memory. So yeah, it's something you don't see very often.
Okay, so just to reset, what we had was a teacher was on the stand, and she was describing what she saw and what she heard. And a really key thing that she said was she described having seen a man in black with a rifle walking on the south side. However, as we learned, she did not tell that to the Texas Rangers when she was interviewed 4 days later. And when she was interviewed just prior to the trial by the DA's office, she mentioned to them that she had seen the man with the rifle, but they say she didn't mention the part about the south side. Because of the way the law is that prosecutor files have to be open, then we're potentially looking at a mistrial here. I think that's going to be the hearing we're going to have tomorrow morning is them arguing this point.
Yes, so what the law is that you're going to hear in this argument whether or not this information is exculpatory. And why that matters is the law doesn't technically require a fully open file. That, like I was saying earlier, is probably best practice for everybody because it saves you this argument.
Right.
It saves the prosecution.
And this is exactly why. We're watching Exhibit A of why it is best.
Yeah.
And I would say for every prosecutor's office out there that is watching this is why an open file will save you a lot of trouble because the laws are different.
Right.
And I will say that rightfully so, because I've covered the criminal justice system for 30 years, and over seen cases where really important information was not handed over, and you saw people wrongfully convicted. And this is why these laws exist.
Yeah.
And they protect everybody.
Yeah. And to my prosecutor friends out there, this is why you should take notes in witness interviews and you should turn them over to the defense. Because look, let's be fair to these prosecutors. You are focused on preparing for the biggest trial of your life. There are dozens, if not hundreds, of witnesses. There's all these moving parts. There's all this video. There's all this body cam. It is a lot. It's impossible to keep every single piece of it in your mind all the time. And so, If you don't turn over everything, you have to trust yourself to say, I know every piece of important information, and I will hear if anything materially changes. And also, even if you think you have a perfect memory and perfect recall, it's impossible for you to know what the defense's argument is going to be, because U.S. law allows for the defense, they don't have to turn over anything.
Well, technically, they don't have to do anything.
They don't have to do anything. So I don't have to give notice of, hey, this is what I'm going to argue, the way in a civil trial, if this was a car wreck or two companies suing each other, those two sides, those two sets of lawyers know the other side's argument very well. But yeah.
Okay, so we're going to bring Rebecca Lopez, our senior crime and justice reporter who's in Corpus Christi, in to talk about the events that have taken place. Rebecca, pretty shocking stuff. I'm not hearing Rebecca.
Yep.
Sorry, I wasn't hearing her. I want to hear her because, okay. And if necessary, we'll just call her on my phone and put her on speaker.
Yeah.
We did that yesterday.
Yeah, it worked well yesterday. Yeah.
Hey, I'm kind of a believer of whatever works.
Yeah.
But yeah, I mean, I am curious to know, because she's there.
Yeah.
I mean,
yeah.
You know,
there's a lot that in looks on judges' faces, what's going on that we're not able to see. And Rebecca in the courtroom is going to be able to give us a better idea of what's happening from her perspective, because, in my experience, some judges are better than others at keeping a poker face.
Right. This judge looked
upset.
Well, because this is probably, of course, I don't know this judge, but this might be the biggest trial he's ever presided over.
Yeah.
And for this DA's office, this might be the biggest case, and not in terms of criminal penalty.
No.
Because it's not, but in terms of exposure and interest from the public.
And magnitude of setting a precedent for law enforcement in mass shootings forever, right? I mean, depending on if they get a guilty verdict on this, it changes everything. There was a time 10 plus years ago that the general thought in the land was you could never prosecute a police officer for a shooting, that no jury would ever find them guilty, and that was borne out every time they would charge a police officer for a wrongful shooting. It was pretty much always a not guilty, and then it started to change. That could happen here.
Yeah, and I've certainly covered some of those cases over the years, Amber Geiger, Aaron Dean, where the rules of the road have changed.
Yeah.
Most assuredly.
Yeah, and being the prosecutor that set the new standard, it's a big deal. Even though this is just, quote unquote, just a 2-year case, there's a lot more to it.
Okay, let's Rebecca's back on the phone. Let's see if we can talk to her. Hi, Rebecca. Can you talk to us about?
Hey, can you hear me now?
I can hear you. Absolutely.
There we go.
We got you. Yeah, we got you. So talk to us about what the events in this courtroom.
Okay.
Pretty shocking stuff.
Very shocking stuff, Tanya. We were all, actually, I was in the press room where we were editing our stories, and then all of this developed, and we all rushed to the television because we were just so surprised by what's happening. And then people that were in the courtroom, some of the reporters, I just talked to them, and they said the families are visibly upset. They are afraid that this could lead to a mistrial, or that there's a Brady violation, which is a very, very serious thing if they can prove that. So of course the judge is bringing everybody back to have that hearing tomorrow, which I'm assuming is going to deal with this issue. But you can see that the families are visibly upset. They've waited for this moment for a long time, and now there's this complication with a witness that has never testified like this before, and caught everybody by surprise, even the defense attorneys, the prosecutors by surprise, or at least one of the prosecutors. Tim Turner looked really almost upset, but with the DA of Uvalde.
Yeah, it was pretty shocking. You and I both have covered a lot of cases, and I don't think either of us have quite seen anything like this.
I have never seen anything like this. And again, I mean, the judge is taking this very, very seriously to bring this witness back Thursday morning instead of continuing on tomorrow and now having this hearing. The judge looks very, very troubled. You can see it in his reaction and how he's dealing with this. And I will be curious to see what Adrian Gonzales wants to do. I mean, this jury was almost. I felt when we were in the jury selection that this jury was hard to pick because there were so many people that already felt so strongly about Adrian Gonzalez' guilt or innocence. They were going to have trouble picking a jury in the first place. So what do you do? Are you the defense and you're going to push for a mistrial so that they have to retry this case? Or do you keep going in hopes that you get a not guilty verdict or set it up for appeal? I don't know. I'm not a defense attorney, but what's the strategy? What does a defense attorney do in this case? Do you think that you have a jury that will be favorable or not favorable towards your client? Based on what I was watching just in selecting the jury pool, I don't think they had a really easy time picking people for this jury. So we'll see.
And to see how different the testimony was, that, what she told law enforcement originally and then what she said at trial. But, you and I have covered a lot of criminal cases over the years. This is exactly why case files that everything should be turned over. We're seeing Exhibit A of that right now.
Well, and then you have a investigator with Uvalde that they brought up right after that, and they said, did y'all ever ask her where she saw the person, where she was standing? Did she ever testify to this? He's like, no. Like, well, why didn't you? I mean, that does seem like basic detective work, and that's been some of the problem with this case and why a lot of people have been frustrated that it took so long and that there's just been a lot of complications. The families have been frustrated by this. The media has been frustrated by this. The Uvalde DA has been difficult to deal with both the family and the media. And so for this to happen.
Yeah,
disappointing to the family.
Absolutely, definitely disappointing. And are you getting any sense of how long the hearing will take tomorrow, or exactly how it's going to be structured? Are we going to see a full-blown hearing or making arguments? I mean, what's your thought on what's going to happen tomorrow morning?
Oh, I think they're going to have to bring in witnesses. It'll be a full-on hearing. There's also some sort of medical issue, so they were not going to start until 1 o'clock anyway tomorrow. So now he's just going to bring him back, hold this hearing, and then see what they want to do, and then bring that witness back. I know that you've got a defense attorney there with you. My question is, did she perjure herself on the stand? Because that's also something that looks like the defense is bringing up. You changed your testimony after the prosecutors presented a case showing where Adrian Gonzales was and where the shooter was, and now you changed your story to put the shooter on the same side as Adrian Gonzales, the same side of the building, the south side of the building. I'm curious what they do with her. Are they going to push for criminal charges? I don't know. It's so surprising, honestly, Tanya. I've never seen anything like this.
Yeah, I mean, it is very interesting. So perjury there's got to be a material change in your either prior testimony or prior sworn statement. And so, one, is it a material change? The defense is definitely arguing yes. Would the prosecution see it that way? I mean, I think they seem to be saying no. Generally, though, when, the state is the one who brings a perjury charge, and so it's pretty rare to see the state's own witness get charged with perjury unless they change testimony so badly against the state, right? If they said something helpful to the state and then they change it and now they're helping the defense and the prosecutor thinks this is I'm being set up, that may be a situation where you see perjury. I would find it very, very unlikely. I think the defense can say perjury all they want, but they don't have the power to bring that.
It feels more like a function of memory. We've seen that oftentimes in these cases. I mean, how many times have you covered cases, Rebecca, where, you know, witnesses' memories are very different?
You know, I mean, I think that is true, but this witness has been interviewed multiple times, and it's been almost 4 years. I mean, I get it; it's a little foggy, but I would think that that is something that you would definitely remember where you saw the person, what side of the building. I mean, that was obviously chaotic, very traumatizing. I mean, this witness testified about how she was worried for the children and the students, and they had to hold little scissors in their hands to defend themselves because they thought no one was coming. I mean, that was all very emotional testimony on her part. But this is very critical to the defense because she's really the only witness that puts Adrian Gonzales on the same side as the shooter, and it blows up the defense's I guess counterpoints to the prosecution if in fact she's the witness that puts him there. Now she tried to say, well, there's going to be other witnesses that are going to testify that they also saw him over there. But initially, all she's ever really testified to is that she heard the shots, that the whole dust and now you see this guy on the other side of the building, that's all new. And I mean, I could see why the defense is concerned. And I think the prosecutor or the special prosecutor, Tim Turner, who's assisting the Uvalde DA, did not seem happy when this was happening. And I mean, the fact that he's questioning the DA about, well, did she tell you this or did she not? I mean, how did not A, prepare this witness better, and B, how did each of them not know what is in the other person's files? You've had a long time to prepare this. I'm just kind of surprised, Vanya.
I am too, and especially on a case of this magnitude. And like you said, these families have waited 4 years, and now here we are, not even really out of the first day of trial, and having to have a hearing where potentially this case we could have a mistrial and have to start all over.
Well, and then the other thing, and I don't know if you guys noticed this, we were talking a lot in the media. It also seemed like some of the witnesses that they brought up, the 2 Texas Rangers, it almost to us felt like they're trying a murder case instead of a case against Adrian Gonzales, not on these state felony charges versus, you know, the evidence that they're presenting, because it just seems like they're trying a whole case that they never got the opportunity to try against the shooter. At least that felt like that to me. I didn't understand why bringing the 2 Texas Rangers up was relevant to what they're trying to prove here. She was relevant because she's going to put the shooter somewhere and she shot him. But the defense, the prosecutors bringing those two witnesses up, I thought was also surprising to us. I'm trying to figure out what the prosecution's strategy is here. Are they trying a murder case against the shooter through Adrian Gonzales? I don't know. It just seems unusual also.
Mike, what do you think about that?
Yeah, it is interesting. You know, the Texas Ranger, I didn't really get how helpful he was to the state. You know, he talked about gun calibers and you know, frankly, it almost just set the defense up for their arguments about Kevlar vest versus plated Kevlar vest, and you know, all of that. It really, yeah, I agree with Rebecca that was an interesting witness choice for what is he doing now. Are they wanting to lay out, this is what I think is happening. The prosecution says, look, the public, the jury expects for us to lay out our cards and explain how does this investigation unfold. You know, who's called, what's their role, what do they do in the, you know, in the investigation. And so they call the ranger, they call the guy who goes out and processes the evidence found from the truck, etc. But I mean, your point, Rebecca, stands that, you know, a lot of that evidence, at least all the evidence found in the truck, is really the shooter, not, you know, that's the murder case talk again.
Right, because obviously the shooter is dead and he is not on trial.
Yeah, this is not his case. Yeah.
And that's one of the things the defense attorney keeps trying to, I think, tell the jurors. They keep stressing that is, do not be caught by emotion. Don't get caught up in your emotions. This is going to be an emotional trial. The prosecution is going to try to show you a lot of evidence that is disturbing. I am telling you, Tanya, I was in that courtroom when they were presenting that 911 call of the pastor, and everyone, was very emotional. The family was crying. The jury was wiping away tears. Some of the media was crying. It was extremely emotional. So now you're going to show them all of this evidence that actually the defense has tried to keep out. One of the hearings prior to opening statements was they were trying to keep out the autopsy reports because it is, they believe, prejudicial to their client because the jury is going to see all this, and they died a horrible, very tragic deaths. People want justice, but is Adrian Gonzales the one that pays for what the shooter did? And I guess that is what the prosecutors are, the defense is trying to say. Look, you guys are trying this case against our client, but it was the shooter. He's the one that did the evil. He's the one that killed the children, not our client. So presenting all of this evidence does kind of support what the defense is saying, that the jury is hearing all of this stuff that will make them very emotional and render a guilty verdict against Gonzales.
Okay. All right, Rebecca, thank you so much for joining us, and we look forward to seeing what happens tomorrow.
Yeah, I'll be there.
Wow.
Well,
very unexpected.
very unexpected. I just hope that we get, full coverage. You just never know, right? Some of these sidebars have not been mic'd, and I hope that we get full access to this hearing, because I think we will.
Well, because they
gave us this part.
Well, and they also had the hearing this morning, the pretrial motions.
That's right.
We're on the record, and we had audio of those.
And I think it would be a very bad look for the judge to all of a sudden close down access and then make a huge decision one way or the other, grant the mistrial or deny the mistrial, and do so behind closed doors after having those doors open earlier. So I would be very surprised. But yeah, even though there's not going to be jury trial testimony, maybe the biggest part is going to be tomorrow morning.
Yeah, well, we'll be back to see what happens tomorrow. And again, just to recap, we are expecting a hearing tomorrow where they're going to be going through the issues with the testimony from this teacher, questions about whether or not the turning over of those different statements to the defense. And under state law, it's an obligation of the prosecutor's office. It's an absolute obligation to turn that stuff over. And as we mentioned, this is why these laws exist.
Yep.
And this is why it's incumbent upon prosecutors' offices to follow them, because you end up with situations just like this. And now we saw this judge look very stressed out because this was took a long time to get to this point. It was difficult picking a jury, and now we're going to wait and see what happens tomorrow.
And everything, it's just granting or denying this motion is not the end of the story, right? I mean, if he grants the mistrial, then we're looking at the state undoubtedly wanting to try this case again. And all of the pain and the suffering and the delay for the victims' families, for Adrian Gonzales, all of it. But if he denies the mistrial and the trial moves forward, this is a big appellate issue. It leaves this case, if there is a conviction, it's not over. And that in and of itself is setting these families up for a lot of pain, because then of course Adrian Gonzales is going to appeal, and of course that appeal, it's probably going to go up at least to the Texas Court of Criminal Appeals, and that's time and delay and pain, and it's keeping this wound open unnecessarily.
Did you catch that? My understanding was he was going to start back up at around 9, right?
At 9, yeah. So I think the hearing starts at 9.
But they were going to end early.
They were going to end early because there's some medical issue, some doctor's appointment that they were already going to end by 1, I think they said.
Well, we will be back tomorrow. Actually, Mike will be joining us again tomorrow as our legal expert. And actually, that's actually really good because given that you've watched all this
saw all this,
and
right.
saw all this, and that's a little bit of serendipity that you're going to be here. We really want to thank you, Mike, and I will be back tomorrow. Thank you for joining us.